I'd like to talk about governance with regard to voluntary agreements from a different perspective. You've heard for years, frankly, that voluntary agreements are faster, more effective, more collaborative ways of achieving results. And I think it would make sense for us to step back and look at some challenges that some past voluntary agreements have encountered and how we can learn from those. Next slide, please. And I'm going to start with another state-led voluntary agreement process, the Feather River FERC agreement reached in 2006. The Water Board did a water quality certification for that agreement. Next, please. The settlement is with regard to the renewal of the FERC license for the Department of Water Resources, the state water projects, Oroville Dam, and all of the related facilities. It's a classic voluntary agreement. It was signed by water agencies, DWR, a long list of NGOs, and local governments. I was starting to make a list of all the water agencies that signed it. It was too long for me to take the time for. A long list of NGOs, local governments as well. Next, please. It's got a familiar set of contents, sort of, in that it addresses flow issues, physical habitat issues. Unlike this VA, it addresses temperature issues in some important ways. Next slide, please. What's remarkable, though, is that 18 years later, the flow has not been implemented, the habitat improvements have not been implemented, the temperature improvements have not been implemented. The FERC license has not been reissued. So all of those, frankly, desperately needed improvements for the ecosystem on the Feather River have not been done. Next slide, please. What has happened since 1906 is that natural production of salmon has crashed in the Sacramento Basin. Salmon season was closed in 2008, 2009, 2023, 2024. New listings, ESA listings, are likely for white surge sturgeon and longfin smelt. Spring run Chinook salmon is likely to be uplisted. I didn't put HABs up there, but they could easily be up there as well. The ecosystem has declined catastrophically in the 18 years since this FERC agreement was reached. And I want to reemphasize the habitat improvements that were promised 18 years ago have never happened and are still desperately needed. Next slide, please. What's remarkable about that voluntary agreement is that the board, having approved it, hasn't held a hearing in 18 years about the lack of progress on that VA, nor, as far as I can tell, has the board asked how it could use its own regulatory authority, including in this process, to require implementation of VA components that were committed to as part of a separate process 18 years ago. Next slide, please. Turn to another one, the Mono Lake water rights decision from 1994, next slide, is, I would call it, a partial voluntary agreement. It was a state board action, but before the state board acted, the previously competing parties, the Mono Lake Committee, LA Department of Water and Power, both supported that agreement and urged the board to move forward. It also then led to a subsequent, I would call it, a more formal voluntary agreement on stream restoration. Next, please. It required the restoration of Mono Lake to an elevation of 6,392 feet above sea level, set a 2014 target date, also had diversion limits in it. And I think one of the ways in which it resembles a voluntary agreement, the one you're seeing today, is that it did not have strong state board oversight for what we all thought was, at the time in 1994, I was around in 1994, we all thought the Mono Lake problem had been solved by this agreement at that point. And here we are 30 years later. Next slide, please. Here we are. Well, that's interesting. Somehow, turn your head to the right. Not sure how I did that. Um, this slide shows a sideways view of Mono Lake since that level. That's remarkable. It doesn't show that way on my computer. What you can see, there's a gray block there that's not easy to see. That's the time period since the 1994 water rights decision. The dotted line is the state board mandated lake level, 6392. What you can see is that for 5 years, LADWP was making progress towards the mandated lake level. And after about 5 years, that progress stopped. And since then, that lake level has bounced around up and down, wet years and dry. If there's a trend in the last 25 years, it's in the wrong direction. It's away from the legally mandated lake level. And again, the target was 1990. It was 2014. We're now 9.5 years after that deadline, the state's target for hitting that lake level. Next slide, please. So, I want to emphasize here that that VA, that partial voluntary agreement, has not produced the lake level that the board expected, the board mandated 30 years ago, 29.5 years ago. And it's worth noting that the state board hasn't taken enforcement action in the last 29.5 years. Now, we hope you'll move forward on that front later this year. But it's really important to note that in these two cases, one of these agreements was 30 years ago, 29.5. Another of these agreements was 18 years ago. This VA has a lifespan of 8 years. We're really struggling with how to make voluntary agreements work when they clearly fail, not just for years, but for decades. Next, please. So why do some voluntary agreements not succeed? Next slide. One way of looking at that is looking at the 5 guiding principles for voluntary agreements that Berkeley Law laid out in their white paper several months ago. They laid out 5 principles: strong regulatory foundation. VAs must achieve outcomes comparable to default regulatory requirements, clear specific biological goals, supported by the best available science, robust and transparent accountability. I'd like to suggest 3 other principles. Next slide, please. First is underneath robust and transparent accountability, and that is that these voluntary agreements absolutely must have strong, ongoing regulatory oversight and enforcement to assure that they're working, that they're making progress. Second, you've heard far more eloquently than I can about the importance of equity in these voluntary agreements. Frankly, in these voluntary agreements, there was not a lot of consideration that I've talked about today. Not a lot of consideration for equity. 30 years ago, the Cosetica tribe is now deeply involved in Mono Lake issues. That was not so much the case 30 years ago.
If I can add, Mono will be the first, because of so much engagement from local tribes, to have tribal beneficial uses. Anyway.
Thanks for pointing that out. This is something that is really changing in the last several years, and it's long overdue, but it's very clear that there's an additional principle here for successful voluntary agreements, and it's equity. There's another one, final one I'd suggest, and that's leadership. And that is, I've been involved in stakeholder negotiations for well over 30 years, and you can tell which are going to succeed and which are going to fail on the basis of leadership, on the basis of basically whether the senior officials involved in the effort look at all parties and say, you're all going to sit at that table, you're all going to make progress, you're all going to make painful choices. And that means beating up everybody in that room, even the folks with whom you often agree. I've been one of those folks. That hasn't happened in this voluntary agreement process. And you can see that by the people, the interests, and the stakeholders that have been excluded from the process. Next, please. So I look at the Feather River and the Mono Lake processes, and they fell short, I think, in particular on two of these principles: robust and transparent accounting mechanisms and ongoing regulatory oversight and enforcement. Next slide, please. But frankly, when you look at the voluntary agreements that are before you today, there are 8 principles up there. The voluntary agreement package that you're looking at today, after 13 years of work, clearly fail all of these guiding principles. Next slide, please. So what do we conclude from this? First, it is not a given that voluntary agreements are faster. It's not agreement that they're not clear that they're more effective than what I'll call a traditional regulatory approach. Many past VA efforts have failed to deliver anticipated benefits. We urge the state board to take action on those past voluntary agreements to make sure that they make progress. This voluntary agreement is by far the most complex ever attempted. And when you look at those 8 principles I just laid out, 5 of them by Berkeley law, that effort has clearly failed. And we believe that that means that the state board must update the Bay Delta plan, including temperature protections and science-based unimpaired flow-based protections. I want to close by saying I don't attribute bad motives to the folks in that table, at that table. They're working hard in that room to come up with an agreement. It's hard. I have sat at the table in voluntary agreements. It's really hard, and trying to do one on this scale is dramatically more difficult than any voluntary agreement discussion, any collaborative discussion I've been a part of. But it isn't a path to success to exclude stakeholders, exclude issues like temperature and tribal beneficial uses and HABs, exclude science and biological objectives. What they're trying to do is hard, and I don't criticize the effort. What I criticize is the product. Any way you measure it, this effort is clearly falling short. Thank you.
Thank you, Mr. Nelson. Ms. Overhouse, good to see you again. Day 3.
Good morning, Chair Esquivel, Vice Chair Diadamo, board members and staff. Welcome back to our 3rd day. I will hopefully try to keep my presentation here short, as once it's up on the screen, hopefully. Great, next slide, please. Thank you. I want to once again express that my preliminary impressions upon review of the draft global implementation agreement make up these slides, but I hope to refine them and inform them as we have more time to review these materials. And I really appreciate the panel this morning on governance specifically. Given the board staff's articulated desire to ideally make these agreements more streamlined or contractual in nature, those were some comments our first day of the workshop, I want to raise some of these legal concerns to help with the integration or nesting under the program of implementation for the Bay Delta Plan update. And I understand that hopefully after I've raised these, even if we can't formally respond today because they are legal in nature, then maybe we can hear more information in the future from VA parties and board staff. Next slide, please. So this is a summary of some of the legal concerns that I had in terms of a preliminary read of some of the new documents, especially they're submitted on March 29th. The first is I'm concerned that especially the draft global agreement may inhibit the state water board's ability to comply with legal requirements and take enforcement action in the event of a voluntary agreement failure. This includes 2 fundamental concepts that I'll go ahead and define later, which is a material modification and then the role of the board as a settling party. The next legal concern or large bucket that I have is that this potentially will inhibit the state water board's ability to fulfill other legal mandates and authorities, such as your delegated Clean Water Act authority, the reasonable use requirement, public trust, and water rights enforcement. And then the third concern I have is that this potentially will constrain other regulatory authorities, such as the Bureau of Reclamation and others, and I'll briefly touch on that. Next slide, please. So the material modification off-ramp is a concept that I understand is usually boilerplate or standard for contractual agreements. I have the definition here up on the slide as well as how it could be used. So material modification here is defined on page 54 of the draft global agreement, and it's pretty broad. So a change in applicable law or a new or amended regulatory action similar in character to pending actions described in section 12.6a that imposes additional constraints on water supply operations, increases contributions of water for in-stream flow or delta outflow, increases required habitat restoration, or increases contributions of funds to an extent that materially impairs the bargained for benefits of this agreement. I think that it's important to note here, because we have discussed in so much detail over the last 2 days that this is a novel, complex scheme that we're trying to ambitiously pursue. This potentially could undermine all of those efforts because it has such a broad definition. And so I just wanted to flag that there for you, especially issues that we've talked about in terms of inadequate temperature protections, et cetera. It may prevent the board from filling those gaps. Next slide, please. The next construct I wanted to bring forward is the State Water Board as a settling party. This code section was referenced both in the VA panel, and I will wanted to pull it out here again for you. This is on page 4 of the draft global agreement. An enforcement agreement means here, with respect to non-federal parties, an agreement executed by a party and the State Water Board pursuant to this section. I wanted to add on that subsection C of this particular code provision states that the terms of a settlement may not be contrary to statute or regulation. Next slide, please. Of course, I do want to give credit that the VA agreement does have this global caveat, which is really important, that does, in theory, protect the board. However, upon first read in other sections, I still believe that the board's responsibilities as a settling party potentially conflict with the board's authorities and mandates. Next slide, please. So the first way, potentially under the Clean Water Act, is that the relevant standard of how the board interacts as a settling party may be undermined. So a good way to explain the relevant standard here was articulated by the board in your 401 water quality certification for the Oroville hydropower facilities, which was issued in 2010. So on page 3 of that settlement, quote, because the State Water Board must exercise its independent authority over any water quality certification it issues, the State Water Board was not involved with and was not represented at the negotiations that resulted in that settlement agreement, end quote. And then another important quote that I wanted to just highlight here is, quote, the State Water Board has determined that certain measures as written in the settlement agreement are either not enforceable, will not protect the beneficial uses, or will not meet water quality standards in a timely manner. Beneficial uses currently impacted by the project may not be reasonably protected if the proposed measure has a management plan with unclear or unenforceable standards. So that's on page 4, end quote, of the settlement agreement. And I think it's just important for me to articulate that standard here because of next slide. Oh, go back one more slide, please. Sorry, thank you. Because State Water Board staff, based on the process of updating the Bay Delta Plan, of course, and us being here to look at the voluntary agreement proposal, have been heavily involved in the evaluation and consideration of voluntary agreement proposals, which in this way have been a settlement. I think that I also wanted to flag a couple other concerns that are bullets here on the slide of that the independent role of board staff has not necessarily been preserved in your water quality certification proceedings in related hydropower projects. And that's something that I've talked to individual board staff about in the past, and how important 401 water quality certifications are, especially when you're looking at how they're integrated with the voluntary agreement. And then when you finalize those water quality certifications for Merced, Tuolumne, Yuba projects, those will inform, theoretically, of course, the Bay Delta Plan update and do provide a separate legal basis. And then I also wanted to flag particularly a section here about how it could be seen that the Water Board is being pre-decisional by signing the voluntary agreements, if you do, as constructed, because of a certain provision here that was applicable to the Tuolumne VA, but the language could be in other VAs for certain tributaries, that the VA itself is subject to withdrawal if the water quality certification does not conform to VA terms for the Tuolumne. So I just wanted to flag that you haven't, finalized that water quality certification. I know that you have an incredible legal counsel So I just wanted to point that out. Next slide, please. The second way under Clean Water Act duties that this potentially may inhibit, the voluntary agreement itself does specify that the board is subject to a dispute resolution requirement. That's on page 22. I just would encourage you to look at those short time windows that are articulated in those particular provisions. And then the board does not control the timeline here. So even though we are talking about an 8-term limit, the VAs are automatically extended according to page 43 if the board regulatory update is incomplete. And so, that automatic renewal or provision, especially to potentially 15 years, I just would like to highlight as a concern for you to further examine. And then we, again, have articulated in the previous 2 days, but once again would like to remind the board that the VAs do not reasonably protect beneficial uses, so that may contradict your duties under Port Cologne. Next slide, please. Reasonable use conflicts. So the board has a responsibility to assure reasonable use of water, and the VA provisions, particularly here for the Sacramento River settlement contractors, preclude the board from ordering reduced diversions in droughts. That's just something that we've articulated in terms of concern, tried to flesh out in the flow accounting session. And I just wanted to pull out that quote for you here in the draft global agreement on page 194. That is of particular concern, especially since we just referenced how this board had to curtail to a historic amount in this last year. And Defenders was really grateful for the staff's work and the board's authority in that. And so we just don't want to inhibit that potential future authority if you should need it. Next slide, please. Yesterday, my colleague, Regina Chicazola from Save California Salmon, highlighted this previous voluntary agreement here. So rather than giving you that context again, I wanted to just highlight that rather than focusing on the fact that these were really recent voluntary efforts that were unsuccessful, I wanted to point out the letter and the phrasing and the role of the California Department of Fish and Wildlife to the Water Board, and really how Department of Fish and Wildlife here is depending on the board to consider the information in those failed voluntary agreements to inform a long-term flow setting process, which is just so important. Next slide, please. A lot of discussion has already been given about public trust resources, so I'll be short here. You already know the standard under National Audubon v. Superior Court. So voluntary agreements replace the feasibility standard with acceptable to VA parties standard. We're concerned that this will put quite a bit of pressure on public trust resources and reverses the role, frankly, of that the board has here in protecting those resources. Next slide, please. And then the next 2 slides I have here are about water rights enforcement conflicts. And so I know that we're short on time here today, so I'm going to be very quick over these next 2 slides. Rather than read them to you, I encourage you to read them, please. I'm happy to answer additional questions, both in writing as well as later in the forums. But I really do want to encourage staff to look at if there's a way we can make sure that this language is maybe informed by our concerns of the board's important authority to really enforce water rights. And I know that that is something that is really intrinsic here in this process. Next slide. So board actions that increases constraints on water supply operations of the State Water Project, Central Valley Project are considered a material modification of the VAs. So hearkening back to my original flag for the definition of the material modification off-ramp here, importantly. Next slide, please. And then lastly, other regulators may be similarly constrained, which is also a concern of Defenders. Sacramento River voluntary agreement is subject to withdrawal if the coordinated long-term operations, biological opinions for the projects limit contracted amounts for those settlement river contractors. So flagging that once again for you. And then as well as the Tuolumne FERC process must conform to a future biological opinion that we don't know yet, or we're subject to rescission. And then I am concerned specifically about there's language on page 63 that there's no application of CISA or the California Endangered Species Act to the Bureau. And I would just love additional insight, frankly, and other opinions about that. Next slide, please. So in conclusion, I think that the VA's non-regulatory regime makes the board subject to VA regulation as it's currently constructed. And so we look forward to hearing more from the board about your concerns if you share those, if you can provide additional information, and of course, any additional clarification from VA panelists is welcome. Reason why I'm bringing this here before the enforcement session is particularly to hopefully give that opportunity, because I know this doesn't directly relate all to governance. It also relates to enforcement, accountability, transparency, and implementation. So I want to acknowledge that and thank you for this time.